Mr. and Ms. Johnson, I want to be clear that the state did not charge you with the death of your child. The state did not charge you with murder, with manslaughter, or even a felony level child neglect for the neglect having resulted in substantial harm. What you're charged with and what you've pled guilty to is gross misdemeanor child neglect. As I stated, I reviewed all the filings that were submitted in the cases, the pre-sentence investigations, the letters of support. They all emphasize that they believe that you did not intentionally harm your child. But again, you're not charged with having intentionally harmed your child. The other point that the letters stress is that you're good people and have a lot of remorse for what happened. And I think your remorse is evident. And it's clear that you thought a lot about this. I have no reason to doubt those descriptions of you, but the truth is that every day in my courtroom, I see good people who made a mistake, and mistakes have consequences. Often the mistakes that I see in criminal cases are momentary lapses in judgment or split-second decisions that are wrong. In your situation, however, the neglect lasted for a minimum of weeks, long enough that the child was in terrible physical condition by the time he died, as the description that was laid out in the complaint. The majority of cases that are charged like yours involve facts of children being left alone for too long, being left in a car, or otherwise uncared for. The underlying issue being they were uncared for and something bad could have happened. When I compare your case to other similarly charged offenses, it is clear that the facts in your case could not be more onerous than other similarly charged offenses. For that reason, I am pronouncing the maximum sentence in your cases. Mr. Johnson, you're sentenced to 365 days to serve. You've got credit for 38 days already served. Ms. Johnson, you are sentenced to 365 days to serve. You've got credit for 2 days already served. These are executed sentences, which means that you will serve the entirety of the sentences at the workhouse. I understand that you have other kids at home. I understand that you don't live in Minnesota. You've also accepted responsibility. For these reasons, I granted your request to do this hearing by Zoom, and I will allow you to select a turn-in date that will work for your schedules. I will also allow you to serve the time at the workhouse one at a time so that you're not both away from your families at the same time. I will grant a standard work release during your sentence, but I'm specifically not allowing electronic home monitoring, sentence to service, or community service in lieu of the workhouse time. The standard $50 fine and $78 fees will apply in each of your cases. Counsel, I need to pronounce a turn-in date. I expect you'll want to have some discussion with your clients. I'm flexible on the turn-in date, and as I said, one of them can serve it first. When the other one is out, the other one can begin to serve it. So I can put you in a breakout room with your clients so you can discuss the turn-in dates.
Your Honor, and if I could have one word.
Go ahead.
I would hugely, from the bottom of my heart, urge the court to reconsider this sentence. I've been doing this for 35 years and handled thousands of cases, including other cases similar in nature to this. I handle serious felonies all the time where plea agreements are worked out and local jail sentences lower than what you've just imposed for this are imposed. I just urge the court to reconsider. I don't think I've ever done this in 35 years of being a lawyer on the record right away and done that, but I am shocked. I can't believe that they are getting the maximum sentence under these circumstances with all of these other players from the prosecutor to probation, thinking that something so completely different should take place. This doesn't take into account anything to do with the family. It's going to ruin everything they've got. They've got all these young ones. I'd ask the court to reconsider. I don't think that this is the appropriate sentence. Thank you.
Your objection is noted, Mr. Lunig. I too have been doing this for a long time, have thought about this very carefully, considered your submissions, and compared this to other similarly charged cases, and I believe this is the correct sentence.